Good morning, this is your Kelso Report for Monday, December 5th, and I'm your host, Clark Kelso. When you hear about suits for securities fraud under Section 10B of the Securities and Exchange Act of 1934, you usually think about class action suits for damages. But in our featured case today, Strategic Diversity versus Alchemix Corp., the plaintiff wasn't seeking damages. Instead, the plaintiff in our case was a major investor in an alternative fuels energy company. And in return for his investment, he received a promissory note in the amount of $500,000, security interests in some of the company's patents and intellectual property, and a warrant that ensured capitalization of the company could not exceed 40 million shares. He also was shortly thereafter elected to the board of the company. In 2002, it became clear the company needed additional capital, and an investor was found who purportedly was ready to invest between 30 and 40 million. But to make that infusion of capital happen, the plaintiff's investment essentially had to be cleared for the new investor. A transaction was negotiated pursuant to which the promissory note was prepaid, the plaintiff relinquished his seat on the board, there was a waiver of the non-dilution rights, a waiver of the right to make further loans to the company, and a release of the security interest in the company's patents. As part of the agreement, the plaintiff then purchased 250,000 shares of stock in the company at a price of $1 per share. 3 years later, in 2005, the plaintiff learned for the first time that the White Knight investor never came through with the big money. Between 2002 and 2005, the plaintiff alleges that he had not received any updates, legally required annual reports, or any communications regarding the status of the company's technology, finance, or development. So the plaintiff sued in 2007, seeking rescission of the second transaction pursuant to which he had been swapped out. The suit alleged causes of action for federal securities fraud, state securities fraud, and common law fraud, among other things. The district court granted summary judgment to the defendant on all claims, holding first that the federal and state securities claims were time-barred. Alternatively, the court held that the claims failed for a lack of showing of damages. On the limitations part of the case, the district court concluded that the plaintiff had knowledge of enough facts to begin investigating whether there was a claim back in 2002, more than 2 years prior to the date he filed his lawsuit in 2007, and the applicable limitation period was 2 years. However, after the district court decision, the United States Supreme Court held in Merck v. Reynolds that while the terms such as inquiry notice may be useful to the extent that they identify a time when the facts would have prompted a reasonably diligent plaintiff to begin investigating, the limitations period does not necessarily begin running at that time, even if the plaintiff fails to exercise diligence and undertake an immediate investigation. Instead, the court held that the ultimate burden is on the defendant to demonstrate that a reasonably diligent plaintiff would have discovered the facts constituting the violation. So the Ninth Circuit reversed the district court's ruling on the limitations issue and remanded for further consideration in light of Merck v. Reynolds. On the issue of damages, the Ninth Circuit first noted that under Section 10B, it is currently unsettled whether rescission or a rescissionary measure of damages is even available as a remedy. At a minimum, the court noted, the statutory framework surrounding Section 10B's requirements was hard to square with the plaintiff's contention that a plaintiff seeking rescission does not need to demonstrate loss causation. So the court held that even when the plaintiff seeks only rescission, that does not alleviate the burden of producing evidence of economic loss. According to the Ninth Circuit, there was sufficient evidence to create a fact question on the issue of loss causation. The misrepresentation that was at the core of the plaintiff's case was that there was an investor ready to invest 30 to 40 million into the company. The loss causation question is whether the plaintiff would have stepped aside and given up his rights if he had known that there was actually not going to be such a large investment. So the case goes back to the district court for reconsideration of the limitations question and the issues of loss causation and the possible recovery of a rescissionary measure of damages. Now, it is just possible the Supreme Court would be interested in the question of whether rescission or rescissionary damages are even available under Section 10b. But the issues are not very cleanly presented at this point in the case. So my guess is the court would not grant a cert petition, and this case is headed back to the district court for further proceedings. And that brings us to our one-liners. First, in the area of involuntary commitment. In People v. Hernandez, the 5th District held that a petition for recommitment of a mentally disordered offender, pursuant to Penal Code Sections 2970 and 2972, can be filed by the district attorney, even though the medical director did not make a finding that the prisoner was dangerous and did not recommend recommitment. The relevant statutes make it clear that the medical director is to focus his or her attention on whether the prisoner's severe mental disorder is in remission and whether it can be kept in remission if treatment is not continued. In the case before the court, the clinician found the mental disorder was in remission, but that he would not stay in remission if the prisoner stopped taking his medication. Based on some history that the prisoner had previously failed to continue treatment when released, the district attorney filed the petition for recommitment. The jury found in favor of recommitment, and the 5th District now has affirmed. Our second case is in the area of inverse condemnation. In Jaffe v. City of Huntington Park, the plaintiff owned property and ran a business adjacent to properties that city officials of the City of Huntington Park discussed for many years as a possible major development site. If the development proceeded, the plaintiff's property would have been purchased or condemned. The conversations and plans about the potential development were openly discussed for a number of years. However, the plans never ripened into an actual approved project. Nevertheless, all of the talk about taking the property allegedly depressed the business, and the plaintiff sued for inverse condemnation for those losses. The 2nd District affirmed the Superior Court's dismissal of the complaint because the plaintiff could not allege that the city ever had approved the development project or announced its intention to take the plaintiff's property. It was all just talk. Well, pre-project planning discussions are insufficient as a matter of law to support a claim for inverse condemnation. Our next case is in the area of environmental law. In Ballona Wetlands Land Trust v. City of Los Angeles, the city had revised an EIR for a development project in response to a peremptory writ of mandate issued by the trial court at the direction of the 2nd District Court of Appeal. After it had revised the EIR and recertified it, the plaintiffs challenged the revised EIR, challenging the project description, the analysis of archaeological resources and sea level rise resulting from global climate change, and the finding of no significant impact on land use consistency. The 2nd District concluded that the revised EIR adequately discussed preservation in place and the impacts of sea level rise resulting from global climate change. The asserted challenges to the project description and the finding on land use consistency were new challenges to the EIR that had not been made during the first round when they could have been. And the 2nd District held that those issues were beyond the jurisdiction of the Superior Court to consider after the prior entry of judgment and issuance of a peremptory writ of mandate. In essence, you can't hold back during a first-round EIR review and try to raise new challenges after subsequent EIR revisions. Well, that's it for today's Kelso Report. Have a great day in the law.